Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, alibiers. Here we are again, deja vu. For those of you that don't have social media, and I know a lot of you don't, Lori's January trial has been vacated and her case is suspended again pending competency evaluation. Well, before we get into that, real quick song fact of the day. Thought of this song, was listening to it literally 5 minutes before the news hit. Folsom Prison Blues. It was obviously written and performed by the amazing Johnny Cash about an inmate at Folsom Prison who wishes he could just hop on the nearby train he hears and go to San Antonio. Johnny Cash wrote the song in 1953 while he was in the Air Force stationed in Germany, and he was inspired after watching the movie Inside the Walls of Folsom Prison. So yeah, here we are again. And I kind of thought this was coming really with just some of the language that's been in some of the filings lately. And then that hearing yesterday, I thought, oh boy, it was not something that we knew about. It was kind of all of a sudden. And so there's no bright side for the families that have to go through this. And really, we're back kind of at square one again. They've been in prison or jail, should be in prison at this point. They've been in jail for over 2 years. And it feels like sometimes we're just stuck in the mud with our wheels spinning. And you think, well, it's October, we're going in January. And then today, boom. So I was thinking, is there a bright side to any of this? Well, not for the families, but I think maybe she just checked off one appeal she can't file for, which is that they denied her the right to a speedy trial. So there's that. And so my point is this. If this thing's going to keep going and going and going and get delayed every other month or whatever, if the defense is going to do anything else to those poor kids' remains, do it now, get it over with, give those babies to the families and let them put them to rest and let them have that peace that at least they know where they are. They can go visit them. That part is over. I can't imagine for 2.5 years what the families have been through to not even be able to have a proper funeral for these kids. So that's my thing. And I see an update from Nate Eaton. Kay Woodcock's statement. It seems the only ones getting their way are Chad and Lori. JJ, Tylee, and Tammy didn't have a choice. Everyone who loved them didn't have a choice. We can't even have their bodies for a memorial service. Where's the justice? It surely is not here. The court is wasting time even considering her competency. She's doing what she does best, playing games and manipulating the situation to suit her wants, her needs. It's a stall tactic. I'm angry and disappointed beyond belief. And I totally feel you, Miss Kay, Mr. Larry, all the family members that are just spinning their wheels while Idaho's, what's going on up there. Good grief. And then it brings up the whole question about Chad. What's going to happen? Pryor has filed for this continuance, and I don't know how that plays into this incompetency. And I'm not a psychologist and I'm not going to try to be, but I mean, does it make his job easier? Does he just say, okay, these trials organically separate and then Chad gets his continuance because of all this? I don't think at this point they'll go to trial together, unfortunately. I know that's the goal of the court because it's so expensive to move it to Boise and everybody's got to go up to Boise and it's tons of money but 2 trials for these families to sit through this stuff 2 times, hear the same set of evidence, to relive it, to re-see it. It's just, it's so much. I don't see at this point, how are they going to try them together? Because she can drift in and out of competency. I mean, when I researched this, when it originally happened, it can be an off and on thing. She's competent for a few months. She's back to being incompetent. And that's, Gosh, it's just, yeah. So I really feel bad for the family tonight. It's just, there's no resolution. And Kay was right in that nobody else had a choice in this matter. Everybody was placed in this situation because two people thought they were gods and, thought the world was going to end in a few months, and boom, just a lot of bodies behind them. So, one thing, if you remember, Archibald, I believe, when he was appointed, he said that Lori watched those court hearings at the hospital. So here's what I think. I think if you're incompetent, you shouldn't be able to watch hearings about the case because you don't understand the proceedings. Just my thing. And for the love of God, nobody asked her to do homework and call a lawyer. Please, we don't need that again. Just don't. So there were a few other filings that were put up today. Shout out to Big E for putting those out. He is the man with the papers, Chasing Paper 89 on Twitter. Go give him a follow. He's a good dude. So the state objects to Chad's request that cameras be allowed in the courtroom. And essentially, they just said, look, we had a hearing. You guys said you weren't coming. You didn't come. And now you want to fight it? They don't even want a hearing for it. They're asking, they just deny it and whatever. Also, the state now, this is a good one. The state objects to Lori and Chad wearing street clothes now that cameras aren't allowed. So yeah, because I've always said, who's going to get prejudiced by you wearing your stripes? It ain't going to be the bailiff or the court reporter or the judge. So yeah, make them wear their state issued clothing to these hearings. The state responded to Chad's request for the second grand jury transcript. And essentially, they just said that this grand jury was impaneled under a separate case number. It was heard by district judge. If you have issues with that grand jury proceeding, remember the second one where there was no indictment, which I've always wondered about because usually a jury will indict a ham sandwich. So what the heck was that about? That they just said that essentially that Chad has no right to that because these are secret proceedings, and the only way the records of a grand jury proceeding get out is, one, it goes to a prosecuting attorney. Number two, a person charged in an indictment or the attorney for the person charged. Number three, a person charged with perjury because of the person's testimony before the grand jury. So they're just saying that, he's not entitled to that. So let's get into the filing today by Judge Boyce. I've got it here on screen. I'll put it in a link in the description for those of you who haven't seen it. It says on October 3rd, 2022, defendant Lori Noreen Vallow Daybell, they have in quotes, Miss Daybell, filed a motion to continue trial, to toll time limits, and to stay case. On October 5th, 2022, the state filed a response under seal to Miss Daybell's motion. The court conducted on shortened time a status conference that same date to discuss the issues raised by counsel in the motions. Due to the legal issues raised by counsel in their motions and during the hearing, and pursuant to Idaho 18-210 and 11, we're going to kind of go through that, by the way. Pending further hearings relating to the competency of the defendant, the court hereby enters this order as follows. That this case is hereby suspended until a determination of Ms. Daybell's competency to stand trial can be determined. That as a result of a need to determine Ms. Daybell's competency, it is impractical for all parties to adhere to the court's May 26th scheduling order. Accordingly, the court sees no other alternative at this time than to vacate January 9th trial for Lori's case. And it says, for the same reasons set forth in the court's May 26 decision and order granting the state's motion to continue trial, the court does not find that the stay of the case at this time violates defendant's constitutional rights to a speedy trial. And they kind of use that argument to bump her to January. If you remember, she was requesting October this month. And they said that it's not the state's fault that she was incompetent and was gone for 10 months. So I think the one thing too to remember is that she hasn't been declared incompetent yet. So there's questions about her competency. So maybe, this time around they evaluate her and say, you're good to go. I mean, that would be ideal, but still, they're not going to undo the ruling that they vacated the January trial. And it's not going to be a quick thing either. It's not like you go to the doctor next week and get a decision. This is going to take time because this is number 2. And then it's like 30, 90, and then 180 days. And then it's just, evaluations after that. So gosh knows, man. End of the world might come before she goes to trial for sure. So back to that, Idaho Code 18210, that's lack of capacity to understand proceedings, delay of trial. No person who, as a result of mental disease or defect, lacks capacity to understand the proceedings against him or to assist in his own defense shall be tried, convicted, sentenced, or punished for the commission of an offense so long as such incapacity endures. So essentially, what they're going to do is the court will appoint one qualified psychiatrist or psychologist, or shall request the director of the Department of Health and Welfare to designate at least one psychiatrist or psychologist to examine and report upon the mental condition of the defendant to assist counsel with defense or understanding of the proceedings. And so it says there's a whole thing about this in Idaho law. It says the appointed examiner shall also evaluate whether the defendant lacks capacity to make informed decisions about treatment. Talks about the cost. If she can afford it, it's on her. We know she can't afford it. Within 3 days, excluding Saturdays, Sundays, and legal holidays of the appointment or designation, the examiner shall determine the best location for the examination. If practical, the examination shall be conducted locally or an outpatient basis. And if the examiner determines that confinement is necessary for purposes of the examination, the court may order the defendant to be confined to a jail, a hospital, or other suitable facility for that purpose for a period not exceeding 30 days. So if she were to go somewhere outside the jail, which I think she will, the county sheriff will have to transport her, and she still won't get coddled because she's still charged with some nasty stuff, y'all. In such examination, any method may be employed that is accepted by the examiner's profession for the examination of those alleged not to be competent to assist counsel in their defense. Upon completion of the examination, a report shall be submitted to the court and shall include the following: a description of the nature of the examination, a diagnosis or evaluation of the mental condition of the defendant, an opinion as to the defendant's capacity to understand the proceedings against him and to assist in his own defense, an opinion whether the defendant lacks the capacity to make informed decisions about treatment. So that means the defendant, by reason of their mental condition, they can't decipher the risks or the benefits of treatment. So if the examination cannot be conducted by the reason of unwillingness of the defendants to participate therein, the report shall so state and shall include, if possible, an opinion as to whether such unwillingness of the defendant was the result of mental disease or defect, or if she's just not wanting to do it. So it talks about filing. The report will be filed with the clerk of court. Copies given to the prosecuting attorney and counsel for the defendant. And if they want to be examined by an expert of their own choice, they should have reasonable access to that defendant. It says, and it goes about being developmentally disabled. We know she's not developmentally disabled. She thought up a lot of really conniving stuff and certainly showed she knew what she was doing was wrong at the time because she lied. I mean, really, to me, like, you can't hide when you're truly mentally ill in a situation where murders have occurred. You go sit, and I've said this over and over and over. When Charles was murdered, you sit in there and say, well, we didn't kill Charles. We killed a demon. That's crazy. That's mental illness. That is somebody who just doesn't get it. You don't tell the investigators who come knocking looking for your 7-year-old boy that he's with, your friend in Arizona. That's, to me, it's just, I've said so many times in the past, I'm not going to get into my opinions on things, and I'm not. So I'm going to leave it there. So essentially, it just goes on and talks about, you know, how this is going to go. And we know how it's going to go. We've been there. So also, the state of Idaho responded to Lori and Chad's motion for the bill of particulars. And it says, and I'm just going to sum this up real quick because it's very long and I just cut half of it out. The court is without authority to hear or grant a bill of particulars, and their untimely objections alleging defects in their indictments and the defendant's motions are thinly veiled efforts to obtain the state's trial theory and work product prohibited under Idaho Criminal Rule 16. And I think that that's, yeah, I'm sure they would love to see what the state has because, they got death on the table. It's not like they got circumstantial stuff against Lori and Chad. It's pretty damning stuff, I think. So ultimately, it says they were indicted as co-defendants on May 24th. Chad was arraigned on June 9th. His counsel filed for an extension of time to file motions through September 10th of 2021 without objection by the state. And then they granted more time until March 9th, 2022. Chad's other motions challenging the indictment were heard on March 23rd of this year and were denied. No additional request for additional time has been made by Chad Daybell. There's no basis for hearing this additional unwarranted motion by Chad Daybell. And it says no application for either a finding of good cause or excusable neglect or a renewed challenge to the jurisdiction of the court have been filed. Now, what's funny is this, the state says in their filing essentially that these were exactly the same motions. And so they're going to state their stance on this jointly with Lori and Chad. And it's like, look, all signs point to the honeymoon's over. Chad's rolled. Lori, with her hair tie wedding ring, clearly has not. And so, yeah, I mean, you got the state calling her Miss Daybell. You got Pryor calling her Vallow. That probably would drive her crazy. So it just goes on to say essentially that they don't deserve it. Among the defendants' chief complaints in their motion is they allege there's too much discovery. Both defendants mentioned the volume of discovery received and under the guise of a motion for bill of particulars request what amounts to the state's work product and trial strategy. The defendants argue because of the volume of discovery and evidence against them, they want the state to provide its theory of the case to narrow down the possible alternative theories that Mr. or Mrs. Daybell would be required to defend against. That's kind of funny. I mean, here's the thing, and Pryor mentioned that he can't find co-counsel to help him. Well, dude, you're like 2.5 years too late. You just now figuring out there's a lot of discovery. And I think the reason he's not finding anybody is because nobody's going to work for free. I mean, look, Chad gave Pryor's house, essentially. I mean, at what point does that kind of go away? Curious to see what happens with that. Because, look, I mean, it's got to be a ton of discovery, y'all. I'm talking terabyte upon terabyte. And for him to try and do it for 2.5 years by himself, I mean, you asked for it. I mean, it's like October. Now you're wanting to go longer. If it were up to Pryor, we would be at trial right now with Chad. And then it changed. And now he needs more time, like another year. So it says further, both defendants again admit the motion to seek have the state define the theories it intends to assert at trial. It's thinly veiled efforts to obtain the state's trial theory. So the state's theory of a case, how it intends to prove the case, and conspiracies and what evidence it intends to admit are not subject to pretrial disclosure outside the rules of discovery. So the conclusion says the state of Idaho requests the defendant's motions for bills of particulars be denied without hearing or denied after argument for the reasons that the court lacks the authority to order a bill of particulars in either case. And at some point in this filing, they talk about the fact that one of the arguments that they used or something was like 90 years old, just insanity. But, I know everybody's disappointed and yeah, I mean, we all are. I thought we were kind of getting there. It's like, but here we are. So what can we do? We can just hope that they give the kids to Kay and Larry and the family members and, put these babies to rest. And that's all we can hope for at this point, because I think everything else is just on hold, y'all. That's just how it is. And this is, unfortunately, if you follow true crime all the time, this is not uncommon. It's just, it hurts. I think it hurts us because we've gotten to know Kay and Larry through this case, and to see them again have to deal with something they didn't ask for is is sad. And then with Tylee's Aunt Annie, and just there's a lot that they deal with that we have no idea about. So the news we hear today, which makes us angry or upset or whatever, they've got a whole other avenue that they're feeling because their loved ones are at the FBI lab or in some hospital somewhere. And that's 2.5 years. They haven't been able to properly say goodbye to these kids. So I think that's the biggest issue. And that's like what we all need to be crossing our fingers for, other than maybe they get a second opinion and that person's like, yeah, you're good to go to trial. But January's off. So it's just another delay nonstop. In this case, insanity. You look at the Wagner case that we're currently doing here, and they were arrested in 2018. And the first one's just now going to trial. I can't imagine that in this case. But, as long as she can drift in and out of competency, I don't know that she'll go to trial anytime soon. Really, I just don't. But it is what it is, y'all. Yeah. So it is. It's been a day. All right, guys. We'll see you tomorrow. Wagner was very short today. There was only ballistic evidence. Literally had a page and a half of notes. So tomorrow, I'm going to combine today's testimony with tomorrow, and we'll end the week with that. And all right, guys, we'll see you soon.